Good morning. This is Diana, and I'm going to give you another title tidbit. Today we're going to talk briefly about Land Trust Conveyances, which is another area that many attorneys and title companies are conflicted as to exactly what the proper method is. So I may read from a couple of title notes to cite properly what I have been provided by my underwriter. When I work with various attorneys, and some of those attorneys prepare something called a land trust. This would be similar to a revocable trust, but the main purpose for our land trusts, as we promote them to the people who are interested in them, is to hold your title in an entity which is legal and has privacy, and as well also acts as a will, if you would like to consider it like that. This way, for a foreign investor, it allows them to hold title in such a manner that it is not publicly accessible, knowing who the beneficiaries will be, if there's going to be a split in assets, and down the road, should something happen to the original grantors or grantor, what the outcome will be at the end. But it does allow them a safe manner of conveyance so that they can transfer the title properly and legally. When we do a land trust, for the purposes of our clientele, we always try to secure the privacy for them because most of them are foreign investors. This is what they're seeking. We don't want their personal names to appear on the deed itself. This for the counties, primarily Miami-Dade, as well as for the county, as well as for some of the other attorneys, reading title creates a bit of a problem or question in their mind, let's say. So they want to confirm, in fact, that it's a legitimate entity and that the conveyance that's being done is being done not just with a phony trust, a phony name. Therefore, I'm going to read for you two things. First of all, in the question of whether or not it is an insurable conveyance, as some of the attorneys question, based on Title Note 31.06.07, and this is coming from Attorney's Title, Old Republic. The one sentence I'm reading out to you says, "The black letter law is that to be a grantee, one must be capable of holding title to land. Thus, to be insured, a grantee must be a legal entity capable of taking title at the time of conveyance." That being said, it basically means that the trust must, of course, be in full force and effect, and then, of course, it can hold title. Going further into that, which is where the ambiguity comes up for some people, it says, "A deed in the name of a trust which can be identified with certainty, such as a reference in the deed to the record of the trust in the official records, or a reference to the date and name of the trust on the deed whereby the trustee takes title, could be held to be enough of a connection between the deed and the trust as would allow identification of the trustee and beneficiary with certainty." In other words, the deed, by naming and identifying the trust, could be held to have conveyed the property in trust in accordance with the terms of the trust, with the legal title vested in the trustee and the beneficial owner in the trust. That means when we do our deeds, we make sure it names the name of the land trust and the effective date of the land trust. Following that deed recordation, we also do an affidavit of trust, which further cites who the principal trustees are at the time of conveyance. By those two documents, they are clearly identifying that there is in fact a legal entity and that trust can be held, and it clearly shows that title is insurable. So hopefully this will help in some cases to clarify in the attorneys and title companies' minds that we are not conveying property in an uninsurable manner. When we do our trusts, we try to keep our confidentiality. For us, again, this is one of the most important things. Again, I work primarily through Grand Realty agents. Grand Realty has agents all over the world, and because of that, a lot of these people want to purchase property in the state of Florida, maybe in other states as well. However, our title insurance is restricted to the state of Florida. And with those conveyances, we want to be sure that they retain the privacy they're seeking, and that they also have a will or will type document associated with their conveyance. So God forbid something does happen, their wishes are followed. I hope this helps you, and hopefully we can discuss another topic on another day. Thank you.